Hello everyone, my name is Advocate Vaishnavi Parate. I am a human rights activist at All India Human Rights Association, and today we are going to discuss and learn about right of adoption in India. So let's start. Start with the introduction. Adoption means a legal transfer. Generally, new couples prefer to adopt a child, not to give birth to a new one. If we see in India, orphanages are full of children as they have no parents to take care of them. Today, many parents give birth to a girl and throw her in the dustbin and don't even think twice. This crime is increasing day by day. In today's generation, also, people don't understand the value of a girl child after so high education qualifications. Half of the population of children is alone and helpless. They don't have legal parents to take care of them. Adoption is the best way to give them a good life. Concept of adoption. Adoption as family building has attracted research from around the world for 3 decades. It is one of the few concepts that has undergone a fundamental change in the process of transitioning from primitive concepts up to the present day. Adoption is a very important institution in our society. It has been recognized for centuries but is part of personal law only now. From the unofficial adoption of a boy to his final rituals, a single female adoptive parent who adopts a daughter. India has experienced gradual change. During the social reforms of the 1950s, India focused on providing housing for the abandoned poor. Since then, significant changes have taken place in the adoption field. Requirements for adoption. There are some conditions of valid adoption given in Section 11 of the Hindu Adoption and Maintenance Act 1956. The requirements are as follows. In case of an adoption of a son, the adoptive parent must not have a Hindu son, a grandson, or a great grandson living at the time of the adoption. In case of an adoption of a daughter, the adoptive parent must not have a Hindu daughter or son's daughter living at the time of the adoption. In cases where a man adopts a daughter or a woman adopts a son, a minimum age difference of 20 years has to be present between the adoptive parent and the child. The same child cannot be adopted simultaneously by two or more persons. Now let's see who can adopt. Under the Hindu Adoption and Maintenance Act, Section 7 and Section 8 provides for the capacity to adopt for a Hindu male and Hindu female, respectively. Both men and women who are of sound mind and are major, that is about the age of 18, can take up a son or daughter in adoption. However, if they are married, then the consent of their respective spouses is mandatory unless such spouse has renounced the world, ceases to be a Hindu, or has been declared of unsound mind by a court of competency. It has to be noted that in case of a man, if he has more than one wife surviving, then the consent of all the wives are required for him to be able to adopt a child legally. Who can give in adoption? Section 9 of Hindu Adoption and Maintenance Act provides for those who are capable of giving up children for adoption. It says that no one except the father and mother of the child has a right to give up the child in adoption, and both of them have equal right of giving up the child in adoption. Since both parents have an equal right to give a child up for adoption, if one of them wants to give the child up for adoption, the consent of the other has to be mandatorily taken, unless the spouse has renounced the world, ceased to be a Hindu, or has been declared of unsound mind by a court of competency. Now let's see who can be adopted. Capacity of a person who can be adopted under Hindu Adoption and Maintenance Act is provided in Section 10 of the Act. It provides that to be capable of being adopted, one has to be a Hindu, not already adopted, unmarried unless a custom or usages, allows the adoption of married individuals below the age of 15 years unless there is a custom or usage that allows the contrary. Effect of adoption. Adoption of a child from another family has several repercussions that are highlighted in Section 12 of the Hindu Adoption and Maintenance Act. The adoptive child is deemed to be the natural child of its adoptive parents from the date of adoption, and all ties the child had with that of his natural family are considered severed and replaced with the ties of the adoptive family. However, the Act provides three exceptions to this rule, which are: the child cannot marry anyone whom he could not have had he been living in his birth family. Any property of the adopted child vested in him before the adoption would remain his, but would come with the obligation to maintain his relatives in the family of his or her birth. The adopted child cannot divest anyone from any estate vested in him before the adoption.